What if I told you the next time a defense lawyer sends you garbage responses to your request for admissions that they also have to send you a check? You know the ones I'm talking about. Due to insufficient information, defendant can neither admit nor deny plaintiff's request for admission. When you see this, I do not want you to get mad. I want you to get excited. Because they didn't just give you a lazy answer, they broke the rules. And in Georgia, when you break the rules, there's a penalty. And that penalty is attorney's fees. And today, I'm going to show you how to get those fees every single time. I'm James Grant, one of the co-founders of Georgia Trial Attorneys. We help other personal injury lawyers make more money, faster, and with less stress by serving as their outsourced litigation department. And as the shooting of this video, we litigate cases for 64 law firms across Georgia. So when it comes to litigation, we don't just guess at what works. We know what works. And today, I'm going to give you a page out of our playbook. Now, that evasive non-answer due to insufficient information is just one of the two things we see all the time. The other is just a blanket denial, meaning they literally deny everything. They deny that a crash happened. They deny that they were at fault. They deny that they were cited, that our client was injured. They deny everything. And when you see this, you can't get mad. But again, see it as an opportunity. Their laziness is your opportunity. And we're going to show you exactly what to do when that happens. And it's a simple two-step playbook. Step one is the warning shot. You're going to send a formal letter to the defense lawyer. And when I say formal letter, I don't mean you're going to print off a piece of paper, stuff it in an envelope, and FedEx it to the defense lawyer. I just mean you're going to send some form of written communication that you can prove was sent and received. Now, this can be an email, which is my preference, but it's totally up to you what you do. And in this letter, your first thing you're going to do is you're going to say your answers to our admissions are incomplete, evasive, and legally insufficient under Georgia law. You're going to cite to the controlling case law, which is a 1973 case, Gregory versus Vance Publishing. And it stands for the simple proposition that you can't claim that you can neither admit nor deny without also providing a reason why a reasonable inquiry was insufficient. That's an evasive answer. And that's going to signal something immediately to the defense lawyer. First, that you know exactly what you're doing. You know the law, and it's also going to let them know that you're willing to hold them accountable. And then you just provide them with a simple ultimatum. Provide us complete, amended responses to our admissions within 10 days. Or else, you're going to file a motion to determine the sufficiency of defendant's answers and admissions. And seek attorney's fees. Now, let's be clear. The defense lawyer is going to get upset when they receive your email or letter. They're probably going to call you, ranting and raving about how unprofessional this is, and how they're going to cut off any common courtesy to you and your law firm in the future. But what courtesy are they really extending your way? What are they going to do? Not give you a discovery extension? That's a nothing burger in Georgia. So this isn't about you being a jerk, but it's about you enforcing the rules. And if holding them accountable makes them uncomfortable, that's a them problem, not a you problem. Now, once you get off the phone with a defense lawyer, one of two things is going to happen. Either they're going to ignore you, or they're still going to provide their amended responses that are evasive, incomplete, and legally insufficient. If either of those two things happen, you move to step two, the knockout punch. You're going to file your motion to determine the sufficiency of defendant's answers and admissions. And this is in accordance with OCGA 9-11-36, subsection A3. And the ask is really simple for the court. First, you want the court to find that the defendant's answers to your admissions were evasive and incomplete. Then, you want the court to deem all of your admissions admitted as a matter of law. And if you did your admissions right, that means you've knocked out a couple things. You've knocked out negligence, causation, and at a minimum, your liquidated damages, which are your medical bills and lost wages. So the only thing left are your unliquidated damages, which is your pain and suffering. Not a bad thing to walk into a trial and tell the jury, ladies and gentlemen, the only thing we're here for is pain and suffering. Everything else has been decided. You're probably not going to get that far anyway. The next thing you ask for in your motion is you ask for your money. Under OCGA 9-11-37 subsection A4, the award of attorney's fees is mandatory. It is not discretionary, meaning the court has to do it. And the only way the defense can get out of that is if they prove that their actions were quote unquote substantially justified. And you know, just like I do, that ain't gonna happen. They're not gonna be able to prove that because you've got a letter where you gave them 10 days to do the right thing, to fix it, to make it right, and they didn't do that. The burden shifts to them. You warned them. They ignored you, and now it's time for them to pay up. This simple two-step process creates a crisis for the defense lawyer and the insurance company. It turns their lazy lawyering into your leverage. Now, for a proof of concept, I want to tell you about one of our former clients, Chanel. She came to us from one of our partner law firms, and we did what we do in every case. Took in the case, filed suit, served it, and began the discovery process. And the defense lawyer did exactly what we're talking about here today. They denied every single one of our admissions, everything. So what do? We followed the playbook. We sent them the 10-day letter. They ignored us. So then we filed the motion to determine the sufficiency of defendant's answers and admissions. And guess what? Before the 30-day timeline was up for them to even file a response to our motion, we received a check in the mail for the policy limits on the case. That's the power of this playbook. It forces a crisis for the defense lawyer and the insurance company where they need to reevaluate their entire position. And to make it even easier on you, I took the template that our firm uses, the one that we used in Chanel's case to get policy limits, and I created a free PDF download and put it on our website. So check out the link in the description for that template. It's got everything that you need. The motion format, the citations, the legal arguments, and it's all completely free. So go download it now. Stop getting frustrated by lazy defense lawyers and start profiting from it. This is how you earn the reputation of becoming a lawyer who just doesn't play the game, but wins. Now, subscribe for more litigation tips and strategies to help you get bigger and faster settlements for your clients. And go forth and make the insurance companies regret all their incomplete, evasive, and legally insufficient responses.